Welcome back, Joe Brunsman, insurance broker to the stars. And for all of you MSPs out there with a Tech E&O insurance policy, well, hopefully you all have them by now. Some insurance considerations to hopefully keep you out of trouble as they relate to this Hafnium Microsoft Exchange Server exploit that's currently going down. Now, non-technical background, I'm just going to presume you guys are well up to speed on this. If you want to, you can pause the video here. But let's go ahead and jump on into those particular what-if scenarios. Now, what if you found those exploits, you removed those exploits, you didn't see any weird outflow of information, it doesn't look like there was any strange access of information. What do you do? Well, it's really important you understand the idea of a potential claim. And I made a different video just for MSPs on this particular topic. But let's follow the bouncing ball here. It says, if during the policy period, anybody at the MSP first becomes aware of a wrongful act which may reasonably give rise to a future claim. Now let's break this down. It says during the policy period. That means you have to report any potential claim during the policy period. That means before you renew your insurance policy. Now, what happens if you knew about something, you didn't report it as a potential claim, you renew your policy and then it becomes a claim? High probability that your insurance company is going to deny coverage on you, which means now you have to deal with the entire thing yourself and you wasted a whole lot of money on your insurance policy for no particular reason whatsoever. That's why people actually hate insurance companies, is this idea, this somewhat ambiguous idea of a potential claim. Now, when it says which may reasonably give rise to a future claim, the term reasonable, that's a legal term, and I'm not going to delve too far into that, but suffice to say it's not what you would define it as or what I would define it as with kind of common vernacular. It's a legal term. All things considered, that's not a line that you want to approach. So if you think you have a potential claim, you really need to consider reporting that to your insurance company before you renew your policy. Now, kind of going back here, it's like, hey, we didn't find anything. What's the big deal? Why are you talking about this idea of a potential claim? Well, kind of some hard questions here that a potential plaintiff's attorney could ask you. Like, are you qualified? Are you certified to be a forensics expert? What's your background here? What's your education? What type of certifications do you have in this particular area that would qualify you to give this particular exact information? That'd be a very, very hard question to ask. Now, maybe you actually do have the background to do this, but you need to be able to answer that question. Kind of some other things. Do you understand the legal side of all of this? So for example, maybe your client has particular obligations under HIPAA High-Tech or FTC Safeguards Rule or Gramm-Leach-Bliley Act or 201 CMR 17 or 23 NYCRR 500 or the SHIELD Act, all of which are in my book. You can get a free copy at the end of this presentation. But there's a lot of potential legal considerations there where that client, they really need an attorney who's qualified in that area to opine on that information, not necessarily just put that on you as the MSP. Now, does your client have any contractual obligations? So this is outside of just the purely, cybersecurity privacy law area. Do they have some sort of contractual obligations? We have a ton of contractual obligations that come across our desk dealing with the cyber insurance side. And there's really some weird provisions in there. And a lot of those provisions you would just have no oversight with. That's really your client's job. And so some of those contractual obligations we see, it'll say something to the effect of, hey, if there is any undue access to your system, you have to reply and report that to whoever, let's say the vendor or the client is. Even if there was no access of information, that's still information we have to know. Now, if your client doesn't do that because they have this false sense of security because they didn't get the attorney as appropriate to advise them on this, they may be breaking legal contracts. And do people actually read legal contracts? Do they keep that at the top of their mind? Well, I'll just say I'm an insurance guy. Insurance policies are technically legal contracts and nobody reads those. So who knows? Next, you'd have to ask yourself, could there be some sort of novel malware on their system that we just didn't pick up? How would we know? Is this in their backups? How far back do we go? How do we know that we actually did everything 100%? Could your client, maybe they're specifically not tech savvy, could your client have a different form of malware in your system that you didn't even look for? Just circumstantially, it happened to have been put in around this time, dealing nothing with this Hafnium exploit, but yet they could still come back and try and blame you and say, hey, you said that we were fine. It turns out we weren't. Potential E&O claim right there. Now, was their information already stolen? How would you know? And finally, there's kind of the three categories here, right? What you know, what you don't know, and then what you don't know that you don't know. And that's really where people can get in trouble, is that third category. Now let's go to a different circumstance. What if you found that exploit, you removed those exploits, you patched as appropriate, you actually did see access and acquisition of your client's information there? What if the client hasn't blamed you yet? Well, could this eventually be construed as being your fault? Now, we know as we sit here, Microsoft has some explaining to do with when they found out about this and when those exploit patches actually came out. But you have to think again, could this be considered a potential claim? Did this happen during your policy period? Could this reasonably give rise to a future claim? Could they potentially blame you for this? Well, could it be construed as your fault? Let's kind of look at some considerations there. It just depends, unfortunately. What damage could befall your client? Could this potentially be a large, excuse me, could this potentially, be a large dollar figure that's going to be hoisted on your client if they have to deal with this? What's your relationship with this client? Are you guys, is your son married to his daughter, or are they a brand new client? How tech savvy is your particular client? Is this something where, maybe they don't know what's going on? You could sit down, you could say, hey, here's the timeline. This is what we knew when we knew it. This is what we did to try and correct the problem. It's not our fault as the MSP, go sue Microsoft, et cetera, et cetera. How tech savvy is your client? Could you explain that to them? What would a non-tech savvy juror or jury actually say about this particular circumstance? That has to be in the back of your mind, because if this isn't something that you could just quickly explain to your Uncle Bob at a barbecue who has no technical background and he'd go, oh, yeah, it's not your fault. If it's not something like that, you need to keep that in the back of your mind. Also, maybe they know it's just not your fault, but hey, they got a big bill here. They had to bring in a different forensics team, an attorney. They had to pay for breach notification, credit monitoring, whatever that case may be. Could they just lash out at you for some type of quick settlement, right? Just trying to claw back some of that money wherever possible, just to try and make their balance sheet a little bit better at the end of the year. You never know. Are they facing financial difficulties at the current moment? And this is something where, if they had to pay for all this breach notification and all the associated costs, that may bankrupt their company. You'd have to keep that in mind. Do they have a cyber insurance policy? That's really important when all is said and done, because you want them looking to their cyber insurance policy, not necessarily your tech E&O policy. Now, we talked about some considerations there on if you would consider this as being a potential claim, as something you would want to report to your insurer. But how do you talk to your clients about this? I've gotten a lot of questions from my clients who are MSPs. They're calling me and they're like, how do we even communicate this without potentially bringing a claim on ourselves, without admitting liability? Well, here's some examples. You could just say, hey, you're all good. Maybe they are all good, but maybe you don't want to necessarily just make such a definitive statement. Next, you could say like, hey, you're screwed, man. You're screwed. You're done. Also, probably not a good business decision or risk management decision. Maybe you could say something kind of in the middle, that you're not admitting liability, but you're not giving them all the comfort in the world where if something did go wrong, they could come back against you. And that could be something kind of like this nice middle ground here. Now, obviously, speak to your own attorney, but here's kind of an example. This is what we've found so far, Mr. or Mrs. Client. However, we are not qualified attorneys. We're not giving legal advice. We're not qualified forensics experts. So given the limits of our abilities and our knowledge and our skill set and the tools that we have available, you may want to consider reaching out, bringing in that qualified attorney, qualified legal expert to further assist you with this investigation, because there's going to be a lot of things that we just don't have oversight with and this may be provided to you under your cyber insurance policy, so consider reaching out to your cyber insurer. That's kind of like this nice middle ground where you're saying, hey, this is what we know, this is what we don't know, this is what we can't do. Here's some additional people who may be able to assist you. Mr. and Mrs. Client, the ball is now in your court. All right, moving forward, how would that cyber policy potentially help your client? Well, first, qualified forensics, dealing with the risk of harm analysis. And it's worth noting that risk of harm analysis is not as simple as, oh, hey, nothing was actually stolen here. Some of that risk of harm analysis, it may be at the state or maybe at the federal or the industry level. They may have obligations there that make the risk of harm analysis different. And maybe, for example, I believe it's Florida, where you have to first consult with, say, local, state, and federal law enforcement before that risk of harm analysis is completed. Whereas other states may just be, hey, if you have no reasonable belief that anything was stolen, aka accessed or acquired, then nothing further needs to be done here. There's a lot of nuances, a lot of differences there. And once again, the breach notification laws that would apply to your client, it doesn't necessarily matter where they're physically located. It's where their clients are residents of. So let's say you have a client near a military base. They may potentially have to deal with all 50 different state and territory breach notification laws. There may be, say, like 23 NYCR 500, where they would have to report it, potentially even if nothing bad happened. There's a whole bunch of stuff that you just wouldn't have any oversight with. Now, the attorney, of course, going to be dealing with contract provisions, all those legal considerations, very much hand in hand with the report that comes out from the forensics. The possibility, and this is situational, of breach notification and credit monitoring, remediation, removal of that malware, and maybe there's potentially other malware on their system, as we talked about before, regulatory fines and penalties. So if it turns out that they were wrong, or I should say you were wrong, and it turns out that something actually did go sideways on your client's computer system, there is a potential for very sizable regulatory fines and penalties. Now, you would obviously want that to be covered under their cyber policy. You don't want that client looking at your E&O policy, because that's going to be pretty painful. And of course, there's a bunch of other kind of situational coverage features inside of a cyber policy. I don't want to go too far into that because it's, like I said, very situational. Now, moving forward, hopefully now you have a lot to think about and a lot of education in this particular area as it may pertain to this particular circumstance. Now, what should you do moving forward? Well, here's some considerations. Now, first of all, I can't tell you exactly what to do moving forward. This is a business decision on your end. As I said before, I am not giving any sort of official insurance or legal advice here. No official recommendation either way. But hopefully now you have a more educated basis to make that decision with your own clients dealing with your own particular business. Now, let's say you do report that potential claim. Is this going to impact your renewal? Yes, there is a probability that it will. We're currently in a hard market. Now, a couple of years ago, it probably wouldn't be a big deal. Nowadays, we've got insurance companies just refusing to do tech E&O for MSPs, just writ large. They're just not doing it anymore. So yeah, it could impact, so your premium. Maybe you're going to have to change providers and your premium is going to go up. Maybe your current provider says, hey, you have this potential claim. We're not going to cover you next year. You're going to have to find somebody else to provide your insurance. Well, you have to make that business decision. It's a cost-benefit analysis of, do you feel safe enough that you don't think anything will reasonably arise from this? Or do you say to yourself, hey, you know what? We're not super comfortable with this particular circumstance. And at the end of the day, we need to preserve our policy rights and make sure that if something does go sideways, we got that big pot of cash that we paid for with our own insurance policy. Now, obviously, you need to read your own E&O policy. If you're watching this, I'm probably not your insurance guy. I have no oversight with your business. I don't know the intricacies of your business, who your clients are, what your specific policy and language says. I just had some examples there. So make sure you're reading your own E&O policy and you're thinking about how to preserve your own policy rights. Keep up with the news. This will be changing and evolving. And understand you may have other insurance policies that could be implicated with this. So, talk to your general insurance guy. See if somehow maybe that general insurance or your business owner's policy, your general liability policy, maybe that would be impacted here. But just make sure that you investigate that as appropriate. And if you're confused by all of this, please seek qualified legal counsel. As I said before, and I'll say it again, I'm not giving any sort of official insurance or legal advice here. This was just some educational considerations for you to hopefully keep you out of trouble. Now, once again, if you're going to be speaking with your clients about this, I do have a different video really kind of built for your clients dealing with some of those cyber insurance considerations, a lot of which was actually mirrored in this video as well. If you want to know more about this, I'll put the link actually up above and you can go ahead and click on that. This is Damage Control Cyber Insurance Compliance. I hope you enjoyed that video. That's where you can download it for free. If you learned something, if you have additional questions, leave a comment below. Share this video with your fellow MSPs out there to hopefully keep them out of trouble. Spread this knowledge as far and wide as you can, or else I do believe there's going to be some MSPs that unfortunately will find themselves in a very, very complicated legal mess with potentially no insurance, and that would be very bad. All right, stay safe out there.